And thank you for joining us today for Securities Law Compliance. My name is Daniel Cotter of the law firm Ehrenberg Golgan, and I'm your moderator today. This webinar is part of the Financial Poise webinar series, Corporate and Regulatory Compliance Bootcamp. Read more about Financial Poise on slide 76. We've also included a slide deck of 77 slides. Please understand from the get-go that we will not step through the PowerPoint in order. They may be up. We may randomly scroll through them at times, but we will not be reading from the slides. Like all FP webinars, this webinar is a conversation, and we have three amazing panelists today to inform you and give you insights. Joining me today are my panelists, Rakesh Gopalan of Troutman Pepper Locke, Stephen Hinton of Bradley Arendt, and Amy Ropke of Ropke Law Office. You can read our bios on slides 71 through 75. Neither Financial Poise nor we intend this to be an infomercial, so you don't have to listen to me read bios as well. If you want more information about us, just look at the bio slides that's in the deck. Thank you to our co-producer, the National Law Review. Thank you to our sponsor, Max Asset. You can read more about the National Law Review and Max Asset on slides 3 to 4 and 75 through 77. The last thing before we begin, page 5 contains a disclaimer. You are not our clients, and kind of like the Michael Cohen notice I refer this as, we are not your lawyers. What we do here today is for your general education and not for you to act on without appropriate advice. If you need legal counsel in these areas, I suggest you call one of the panelists for additional guidance, and they can become your lawyer if you want them to. Without further ado, here we go. We're going to discuss the sources of federal securities compliance today, the effect of federal securities compliance on state law fiduciary duties, and how corporations operate, some guidance for board members in light of securities compliance, and a discussion of independence to highlight, among other things, the impact of the exchanges on securities law compliance. We will also discuss traditional SEC disclosure and the various documents filed with the SEC. We will discuss internal controls under Section 404. We'll talk about the companies that have been impacted by the cost and complexity of SOX compliance, and finally, some of the relief for those types of companies. The way in which corporations operate, particularly the laws that govern their relationship with their investors in the marketplace, are governed by state and federal law, though not limited to state and federal law any longer. So let's get started, and want to turn to our first question. Rakesh, there has been a lot of rulemaking activity from the SEC recently. Can you briefly highlight some key areas of this regulatory rulemaking activity?
Yes, thank you so much. So T+1 settlement was over a year ago, May 2024, when it was implemented, but it's been a significant shift to securities transactions that affect lawyers in particular, as well as bankers. The standard settlement cycle for most securities transactions has been shortened from what used to be actually longer than that, T+5, T+4, T+2, after the trade date, to T+1, which is 1 business day after the trade date. So that's just something that I wanted to highlight. And as folks plan, a lot of times it does create a crunch for transactional lawyers. And most importantly, it creates some difficulties with some other dependencies that are not just a matter of making sure your lawyers move faster, including getting auditors to provide consents and opinions from law firms and things of that nature. The next sort of really important thing, which is pretty timely, is the EDGAR Next implementation. So EDGAR Access currently requires new login.gov credentials, which creates a better centralized and secure method for companies to manage their access controls to their EDGAR filings, rather than what has historically just been writing on a piece of paper or on a spreadsheet all the different various EDGAR access codes and shuttling that document around via email. But the compliance deadline is September 15th, which is less than a week away. And for the most part, if people have current unexpired EDGAR codes and ready to go and they have access to them, it's pretty easy. Even now, there's time to create those credentials and provide the access authority to the various financial printers, for example. But if codes need to be reset, the SEC is extremely behind in resetting those Edgar codes. It may take even up to 30 business days, we're hearing. So if you've not transitioned to Edgar Next already and you have an access code issue, you will not be able to make Edgar filings. It's sort of as simple as that. The SEC's regulatory flex agenda, which is sort of the name that the SEC has been giving to a lot of their initiatives to update and streamline disclosure. It includes several rules that are in various stages of rulemaking currently, including updates to foreign private issuer eligibility, Rule 144 safe harbor, cryptocurrency changes, emerging growth company and filer status modifications, shelf registration modernization, exempt offerings, disclosure practices, as well as shareholder proposal modernization. So those things are in various stages of rulemaking and the comment process, and they'll come out in due course. The most significant of with every new administration, there's obviously some sort of modification to prior regime rules, and there often are changes in interpretations and things of that nature. But the most significant one for this administration has been the rolling back of the climate change disclosure, which really wasn't a technical revision or modification to the rulemaking, but rather the SEC decided and voted to end the defense of the rule, which was in litigation. So procedurally slightly different than some of the other formal rulemaking withdrawals. Daniel?
Well, thank you. And that 30-day is just shocking, but not surprising. But anybody that deals with any government system at any time, they're severely outdated. And so when they bring up technology, it's crazy. And that was a great introduction of some things happening. So thank you. Stephen, I want to turn to you. And can you please introduce us to and distinguish between state law, especially state law fiduciary duties, and federal law, including Sarbanes-Oxley?
Certainly. So as we all remember from American government class in high school, we have a dual system of government in the US. So federal laws that apply to all states, and then states have their own laws. And in many cases, these overlap. So we're going to talk about some of those ways they overlap today. And the first is to talk about fiduciary duties that apply to directors and officers of a company. In particular here, talking about publicly traded companies subject to SEC reporting. So fiduciary duties, for the most part, are regulated by state law, and specifically the state law of the state or other jurisdiction where the business entity, the corporation, for example, is incorporated or formed. And so if a Delaware corporation has a question about fiduciary duties, it's going to be governed by Delaware law. While there are meaningful differences in fiduciary duties among the different states, they can typically be boiled down and summarized in their most common formulation as two duties: a duty of care, which is a requirement for directors and officers of a corporation to act with the amount of care that a reasonable person would do in making an informed decision. And then the second duty is a duty of loyalty, which imposes an obligation on directors and officers of a public company or any corporation really, to act in good faith in a way that's in the best interest of the corporation. That would be as opposed to acting in a way that involves self-dealing or a conflict of interest. So these are the core fiduciary duties governed by state law and state judicial decisions. So the court cases that apply these laws fill in a lot of the details just outside of the state corporate statutes that apply fiduciary duties to the corporations. So when we talk about that, then we're looking at state law. The preeminent state is, of course, Delaware. That's where a majority of publicly traded companies are organized. One of the updates that I want to talk about this year is a trend that's been referred to commonly as Dexit, which this is the first time I've ever said that word out loud. I had to look up how to say it, but it's refers to a trend in recent years for publicly traded companies to move away from Delaware as the preferred jurisdiction of incorporation. And the move is really intended to get to certain states such as Nevada or Texas or Wyoming that are viewed as being more management friendly than Delaware has been perceived in recent years. The most high profile move would be Tesla's move away from Delaware to Texas in response to litigation involving Elon Musk's pay package there at Tesla. This is still a developing area, but it has resulted in changes by the Delaware legislature to Delaware corporate laws, and specifically those that relate to fiduciary duties. So to bring that back around, fiduciary duties that apply to public company officers and directors are governed by state law. Now shifting gears over to federal law, and specifically for this topic, federal securities laws. So there is, even in the context of securities laws, a dual system of laws. There are state securities laws, but in many instances for publicly traded corporations, those are going to be preempted by the federal securities laws. And so the primary laws there were adopted actually back in 1933 and 1934, and they governed the offering of securities in the US, both public offerings and private offerings, and then the disclosures that have to be made by companies that become an SEC reporting company, whether that's because they're listed on an exchange or because they have a certain number of shareholders. And so those are intended to get adequate information to investors and the securities markets in general, to develop robust markets, encourage trading, and to prevent fraud. And so those federal laws are going to be mostly focused on disclosure and getting information out to shareholders. They've been around for a long time. Some more recent developments, specifically that are very commonly known about and were very important, were the Sarbanes-Oxley Act of 2002, which is focused on the quality of financial reporting, and then the Dodd-Frank Act of 2012, which was focused more on governance reforms that came out of the financial crisis of the late 2000s, specifically things like compensation-related disclosures and practices. And so that's a summary of sort of the key federal and state laws that apply in the context of fiduciary duties. Again, state law applies more broadly for fiduciary duties, but then for public companies, their securities offering and SEC reporting is going to be governed by the federal SEC regulations.
Thank you. And a lot of laws are going to be aware of and how they interact. So thank you for that. And the Dexit will continue to be an issue that we'll see. Sometimes I scratch my head on some of the choices that are being made, but that's there's a lot of books out there about tax-free in Montana or Wyoming, and so people are grasping at, although it's probably a topic for another day. Turning now, Rakesh, back to you. What other federal laws and other rules and regulations impact corporate securities compliance?
I would say the primary one relates to the independent self-regulatory organizations, the NYSE and NASDAQ, and each one of those has different tiers. NYSE Amex, as well as, for example, and NASDAQ has the global market, global select, as well as the capital market, which have slightly different requirements and thresholds. But broadly speaking, these exchanges have requirements related to the independence of directors, specific audit committee requirements, specific compensation committee independence requirements, and various definitions of independence and certain categorical bars and guidance related to what exactly constitutes being independent from management in the context of a public company director. They also include accounting requirements and several other rules and regulations related to corporate governance and disclosure. And so I think a lot of people who aren't ordinarily practicing in securities every day might find it surprising that a lot of these core governance and independence requirements actually come from the exchanges and not the SEC themselves. Now, of course, when these organizations, when the exchanges do want to make a change to the regulations, they do have to get SEC approval, but nevertheless, they are housed at these exchanges. The next organization that's sort of very relevant to public companies would be the PCAOB, which is the Public Company Accounting Oversight Board, which was created back after Enron and Sarbanes-Oxley to oversee the auditors of SEC-registered companies. And it was found at the time that the SEC was not sufficiently focused on the audit function and the rules and independence requirements in that realm. And so the PCAOB has been operating ever since and conducts audits and a whole number of things that relate to the oversight of auditors. There has been a move this year to, and over the years, but also this year, to enact legislation to abolish the PCAOB. I think some of the headline grabbing was a little bit misplaced because, ultimately, the legislation would have moved those functions back into the SEC. It wasn't necessarily proposing abolishing the concept of auditor oversight. Now, we can debate whether that's a good thing or not, but that's at least what is currently pending. But nothing has happened officially on that. That's not really moved along a lot. There are other sets of rules that really come from the SEC, primarily related to internal control over financial reporting, whistleblower policies, codes of ethics, legal compliance programs, trading policies, and violations and waivers of these policies can have major consequences, both internally at the various public companies, but also in terms of disclosure requirements from the SEC related to waiver of ethics requirements, violations by certain of the individuals associated with the company. So, Daniel?
Thank you. And again, a lot to digest and a lot to consider. So very complex area of operations and governance overseeing the companies. Amy, want to turn to you now. Could you share how in-house counsel can help a board move from a check-the-box compliance culture to a governance culture that actually strengthens decision-making?
Sure. Yeah, I think it's helpful to take all of the framework that Kesh and Stephen have talked about so far and think about how that applies to your board and your board's governance. And governance itself is a culture. It's not just a check the box type of thing. When you're wanting to comply with the policy, you're adopting a policy or waiving a policy, you should be checking boxes and making sure that the filings are on time, you've got the right disclosures, and the audit committee has its charter in place and it's been updated and all that. But compliance by itself does not make a board effective, and really that's what you need in order to reduce risk. So let's look at this through the lens of governance. Governance is how the board, or it's really about how the board actually makes their decisions, how they exercise oversight, how they create a culture of accountability. So a board can have all the policies in the world, and I tell my boards this as well. But if you never open the binder, then what is it worth? If the directors aren't asking hard questions, if your management isn't surfacing issues until they're a crisis, and the board has to make these decisions, always in crisis mode, then the governance process has not been successful, even if technically the compliance obligations have been met. So just as Stephen talked through the fiduciary duties of the board, that's what I think of as the bridge between governance and compliance. The fiduciary duty is about following the law, but it's also about more, right? Our board members are learning how to exercise care and what that looks like in their situation, and loyalty as well, and how you approach the decision. So that's why I think you should look at your boards from the perspective of both compliance and governance and look at them together. I've seen boards that lean too heavily on the mental checklist, and that's why I urge caution to just make sure you have the policies, but also make sure that you're understanding from the governance perspective what that means for you and in your board in implementing those policies. So educate the boards, and make sure that as far as either your culture goes, your board culture goes, that you're really taking your boards through what these policies mean in the context of what the issues are that your organization is facing.
Excellent. And yeah, I often talk about tone from the top and not being tone deaf. And the
Yeah.
perfect poster child for, I think, an example of where there was a disconnect was Enron. You know, they were seen as the ethical company of the year. They had a no tolerance policy, wink, wink, and we see what happened there. And so, can you that was great about the SEC and compliance and governance. Can you also touch on how boards should be preparing for emerging cross-border and global compliance risks like cybersecurity disclosures, ESG, although maybe that's off the table right now, but you can go into that, or foreign ownership reporting, so they don't get caught flat-footed?
Yeah, for sure. Yeah, when I think about areas where the boards need a firm grounding, I'd put personally data protection and cross-border securities transactions at the top of my list. And it could be because that's what I've seen the most often. You're right. ESG has gotten a lot of attention, both good, bad, and all the others. I don't see it going away. It's still an issue. But what I'm seeing right now are boards that are being caught in the intersection of their securities compliance with privacy laws and foreign ownership rules. And we're in a global economy, and our boards have to think globally when there's a chance or a situation that comes up where shareholder or investor information is being collected. It doesn't just sit inside your SEC filings anymore. Your companies are collecting, they're storing it, they're transmitting that data across borders. And so which borders are we talking about, and which rules do you have to comply with? And that's where the data protection pieces come in. Of course, we've got the GDPR in Europe, and California's CCPA, and China's PIPL, and there's US securities disclosures rules on top of that. So there are a lot of different layers to data protection that boards may be thinking just sit with the executives. That responsibility sits with the company, and they have it handled. But no, you really need to think about that and be involved at the board level as well. And that's really because it's not just an IT issue. It's not just a management issue. So touching just real quick on cross-border securities ownership, that's a whole nother ball wax, I guess I would say. It's not just who owns your shares, it's where those owners are located, what jurisdictions they fall under, whether they trigger, the wonderful beneficial ownership filings, which is also a kind of a hairball, or national security reviews, right? We've got anti-money laundering laws, and where's this money coming from that your shareholders are investing in your company? So thinking about it, where you've got different countries that have different rules and thresholds for ownership, your boards have to be aware of what those risks look like. So I'll take my boards through sort of some tabletop exercise about, like, here's a hypothetical, or here's what we're thinking might happen. How do we approach this? And that gets my board members thinking about what that looks like for them in terms of governance issues, and not just a technical issue. Back to you, Dan.
Sorry, for some reason, there's an annotation button right by my mute button, and so I keep hitting that, and then it pulls up that I don't know, I don't even know what I'm annotating, honestly, but thank you for all that. And again, I think those are all important issues, and you mentioned the beneficial ownership. For those that follow that, the CTA became a dud for US-based companies, and also it's a weird, generally, when you have a situation where you thresholds, it's over 5 million, but that was 5 million or less, so it's still a very small threshold. So applies to foreign. So thank you for all that. Rakesh, what are some of the best practices you have found help to comply with the securities laws, regulation, and rules that we've discussed so far?
Yeah, I mean, a lot of it is so keying off or continuing off of what Amy has shared. A lot of it is that here are some, items of or areas of securities laws that I think companies may not want to focus on, but probably should, at least sort of as an insurance policy, CYA, prophylactic, call it what you will. Number one is really making sure that the independence determinations are properly done and redone on a yearly basis. There is a requirement for those determinations to be done, but often it's perfunctory and we just copy the resolutions from the prior year. And there's a lot of board entrenchment. So board members who are there for a long time, and there's often, I find, no discussion as to whether they're still independent. 9 times out of 10, or maybe even more often than that, they probably still are. But circumstances change. People have families, situations that change. People have children that all of a sudden grow up to be adults and have jobs at these large organizations. So it's really important to make sure that to take the D&O questionnaire seriously, to have even beyond the D&O questionnaire, just make sure that you have a robust conversation and understand the situation for each particular director, to make sure you don't accidentally go a period of time, any period of time, with a non-independent director. This sounds self-serving, but reliance on professional advice. And I guess to make it less self-serving, I would include other non-lawyers as well in there. There are proxy advisors that can be very helpful. There are governance professionals, there are compensation consultants, there are tax advisors. There's a whole suite of advisors that are really, really relevant. And although a lot of them are quite expensive, even for small companies, it can be very helpful to ensure that there's a second set of eyes and that there's a bringing into the company a sense of market practice and how things have changed. Maybe an obvious one: proper record keeping, minutes of meetings, keeping board evaluations, board education. These things are, again, they kind of often are the lowest priority for in-house counsel or companies generally. But when issues come up later, or if there's, God forbid, some sort of securities lawsuit or fiduciary duty issue or lawsuit, these are the things that we can look to for proper defenses of exercising properly the fiduciary duties.
Thank you. And Stephen, where does independence come into play in corporate governance, and how does the SEC govern the issue of independence?
Yes. So again, I get to talk about our federalist system of government. So we have multiple layers of independence requirements. But similar to the topic of disclosure versus fiduciary duty, there are differences in how they're applied and what they're focused on. So first of all, going back to our state law concepts of independence. And so most commonly talk about Delaware jurisprudence. So under Delaware law, there are entire cases that focus on different situations where a lack of independence among directors may result in a heightened level of judicial scrutiny of a decision. So for example, if there's a situation where a majority of a board of directors is subject to litigation, or a claim by a shareholder, a derivative claim that there should be litigation by the company against those directors, and those directors are making a decision, well, do we cause the corporation to bring this lawsuit or not? They really have an interest there. They're not exercising independent judgment under Delaware jurisprudence. And so Delaware courts are going to tend to impose a higher level of scrutiny. You also frequently see this in the transaction context, where a board of directors is weighing a decision of whether or not to sell the company. They often, and usually they have an interest there. If they have sort of a stake in the company that they're having to weigh versus just what's the best course of action for the company in general. Again, Delaware courts will apply a higher level of scrutiny. But applying this independent analysis, when you have a situation where some members of the board are not subject to that conflict of interest, Delaware courts have recognized that when you appropriately delegate decision-making to a special committee composed of independent directors who are free from that conflict of interest, it can actually lower the level of judicial scrutiny on those decisions. So that is under state law, looking at fiduciary duties and director independence, focused on those types of decisions. Separately, the SEC and the stock exchanges have concepts of independence that apply to public company directors. So starting out with the SEC, the concept of independence here is largely independence from the management of the company. And so, obviously a CEO who sits on their board of directors is not independent from management. They are management of the company. And so when they are acting as a director, it's very difficult to see that they're going to separate the decisions they make completely from their role as a member of management, and also be able to exercise the same level of objective oversight and challenging of management that an independent director who is not a member of management, doesn't have a close family member who is part of management, doesn't have other financial arrangements with the company that might impact their independent judgment. So we look at SEC rules and then also stock exchange, they're focused on that separation from management. So the way then that these independence requirements apply, stock exchange rules require most companies, unless an exemption applies, to have a majority of the board composed of independent directors. And there are specific definitions, both for NASDAQ and the NYSE, for what what it takes to qualify as an independent director. Although I will say, Rakesh mentioned this before, there really, though, is a holistic assessment that has to be made. You can't just go through and check the box and say, okay, we don't have these specific things, because a determination does have to be made by the board that directors are independent. So we look at those specific things, and then particularly under SEC rules, but also under exchange requirements, there are heightened independence requirements that apply to members of audit committees and compensation committees. So for example, a member of an audit committee on a board of directors cannot have been involved in the preparation of a company's financial statements over a certain period of time, generally 3 years, so that they are going to be objective in assessing management's preparation of financial statements. Similarly, compensation committee members can't receive any compensation from the company outside of their service as a member of the board and its committees, so that they are going to be objective in weighing whether or not management's compensation is appropriate. So that's sort of the division of independence requirements between state law, SEC requirements, and the exchanges. And then where a lot of this comes out and is disclosed shows up in the proxy statement that companies generally send to their shareholders each year. There are specific SEC disclosure requirements for companies to say whether or not they meet these standards and why they've chosen certain things, to consider certain things in making these independence judgments.
Thank you. Rakesh, Stephen talked some about the exchanges, but you want to go into a little more detail about the exchanges and some of the role they play in independence?
Sure. And we mentioned it, I mentioned it earlier as well. We'll start with the NYSE definition of independence. And NASDAQ is largely the same with a couple differences I'll mention. But the key, again, as we've mentioned a few times, is independence from management. So the exchanges basically say even significant stock ownership, subject to certain situations, is not necessarily a bar to independence. You just want to make sure that the interests of these independent directors are aligned with the stockholders and not management, who might have other incentives relating to their compensation. The exchanges outline specific details for audit committee independence requirements, which are more exacting than general independent directors requirements related to not being a current partner or an employee of a company's auditor, which sort of seems obvious, but it is definitely a key requirement, and other personal relationships and family relationships related to the audit or the absence of those relationships with the company's auditor. The exchanges also have certain compensation and business relationship tests. So you've got to make sure that there's no compensation committee interlocks, which is essentially where director of one company or immediate family member is an executive officer of another company, and then the executive of the first company sits on that other company's compensation committee. So you want to make sure that they're not indirectly approving each other's compensation and doing each other a solid. There's significant business relationship tests. There are certain tests related to the payment to a particular director's company or even nonprofits. Then there are more, I guess, clear or obvious ones related to the impact of having an immediate family member at certain levels of these companies, and whether the independent director was an employee of the company. As I mentioned earlier, a little more on the audit committee independence rules. Even though the exchanges have their own rules, the SEC also has, under 10A3, certain requirements relating to the audit committee independence requirements. Not being an affiliate of the company, can't have received directly or indirectly consulting, advisory, or compensatory fees, and things of that nature. As I mentioned, the NASDAQ definition is quite similar. Some of the key differences is that NASDAQ does not have a significant business relationship test, and some of the charity requirements are slightly different. But if there is a situation where there's any sort of relationship that is of question or of any tie to the company, it's really important to consult in-house counsel and external counsel for those assessments.
Thank you. Stephen, let's turn to some of the documents that get SEC review. As far as shareholder communications, what does the SEC review, and what are the biggest issues related to shareholder communications that it faces?
Okay, great. So as we start to build out the core public company disclosure documents, I'll start by talking about a proxy statement. So the proxy statement is sent out annually by most publicly traded companies if they are going to hold a meeting of shareholders, which under Delaware and most other state laws is required annually for the election of directors, unless there's some exemption, such as the company is controlled by one stockholder or a large group of stockholders that are able to deal with that in other ways. But the proxy statement is the primary governance disclosure document that it gets filed with the SEC. It then does get sent out to shareholders. It has to be filed with the SEC before it can be sent to shareholders. And the SEC has a list of things that has to be included in that proxy statement. I'll keep hitting on this federalist system concept. While Delaware doesn't necessarily have a list of things that has to be included in a proxy statement, or any other state, there are requirements under Delaware jurisprudence that material information be provided to investors so that they can make an informed voting decision. That should be kept in mind as well. It syncs generally with the SEC disclosure requirements to give investors the information they need. So in almost every annual meeting, there will be an election of directors. There'll be certain other items we refer to as routine items, most commonly the approval of auditors. Why do we do it? Well, it's so that brokers can vote at the annual meeting without getting instructions from the beneficial holders, and that helps companies achieve quorums. So you almost always see an item requesting approval of auditors. And then other frequent topics are approval of additional shares to be included in a company's equity compensation plan. That is mandated by stock exchange requirements. SEC rules also allow shareholders who meet certain requirements to include proposals on permitted topics within the proxy statement. So you often see those. And then there are some compensation related voting items that arose out of the Dodd-Frank Act, including the say on pay and say on frequency. No, this wasn't Dodd-Frank. This was prior to that. Say on pay and say on frequency votes where shareholders are asked to vote on whether they agree essentially with the company's pay practices. And so again, the proxy statement gets mailed out to shareholders. There's actually now an option to send out a notice, one-page short notice, and shareholders can then go and look online instead of having to print out full proxy materials. so that can be environmentally friendly. And along with the proxy statement, there is a requirement to send an annual report. Often, well, for some companies, this can be a very heavily designed marketing type document to communicate how great the company's been doing and how impressive their management team is. For others, it's a more simplified document. Essentially, it's the annual report on Form 10-K that we're going to talk about later. That covers most of the things that have to be in there. There are specific SEC rules around the timing of when proxy materials have to be filed and sent, along with if you're going to use the notice only version there. And so you need to be aware of those as you prepare your materials. And so, Daniel, I think Rakesh is going to talk about some more.
That's great, and thank you for that. And for those that haven't ever attended an annual meeting, if you've ever worked in house or attended one, they're usually boring unless you're going to Berkshire Hathaway, who, by the way, Warren Buffett, if you want to see the more elaborate thing that Stephen was talking about management and also hits and misses, you can't do any better than looking at the annual reports from Warren Buffett over the years and talking about flow, talking about all kinds of things that are really good stuff. Back in the day, Ben and Jerry, before they went dark and sold to Unilever, right, their independent streak over, they used to do a comic book formation at times, which was really great. It talked about different roles and different statements. But anyway, Rakesh, there are several disclosure documents filed with the SEC. In addition to the proxy statement, including the 10-K, 10-Q, and 8-K. What goes into a 10-K and what are the filing deadlines for the 10-K? Could you also speak a bit about the SEC's recent focus on ESG and AI matters?
Yeah, and this question can actually probably take an hour or 2 hours, really, because it's, the 10-K is the primary and probably longest document often that companies file, which is basically the year-end filing with annual financial statements. The timing of filing depends on the size of the company. It's 60 days after the fiscal year end for large accelerated filers, 75 days for accelerated filers, and 90 days for all of the companies. But it relates to not just the financial statements, but executive compensation, directors, certain corporate governance matters. Now, a lot of those things can be forward incorporated, meaning that the time you file the 10-K, you can say that you're not going to include that in the 10-K, even though it's ordinarily required, because you're going to file a future proxy statement. And as Stephen mentioned, that's where a lot of that functionally is housed. As long as that proxy statement is filed no later than 120 days after the fiscal year. And so there are all sorts of rules in order to be able to avail yourself of that exemption, but it includes management's discussion and analysis of the financial results and the operation and financial condition of the company and a number of other items. So historically, at least in the last probably 5 to 7 years prior to this year, the SEC has focused a lot on ESG, including greenwashing claims and different things related to what companies should disclose, how they disclose it, and what level of disclosure needs to be included. That has dramatically changed with the new SEC and the new administration. And as I mentioned earlier, a lot of those things have been challenged in court and sort of are now effectively dead on the vine. The SEC had also been focused on AI washing, which I do expect and is not remains to be seen, but I do expect the SEC to continue to focus on this. This is an issue that we are seeing a lot of throughout the industry, which is everyone wants to say that everything is AI, and we know that's not the case. And we know that companies are not all AI companies, but it sure feels like they say they are. And so a recommendation for anybody working with public companies is whenever you see those kinds of words, whether it's in SEC file documents or not, make sure that there is a valid and defensible argument that the components or the products that they're talking about really do have some sort of AI component. If not, consider softening the language or describing it a slightly different way, because that could be the subject of SEC action, comment letters, or litigation in the future for misleading claims. The 10K also includes the auditor's report, as I had mentioned earlier, regarding the financial statements, and then also certifications by the CEO and CFO that there are no misstatements or material omissions, and with certain exceptions regarding the financial reporting controls and disclosure controls. Back to you.
Thank you. And Stephen, focus on a 10Q and what are the filing deadlines for the 10Q? And can you answer also why it's a 10K and not a 10A if this is a 10Q?
Okay. All right. Daniel's trying to stump me here. So first of all, I'm going to circle back because I shouldn't have second guessed myself. Say on pay was the Dodd-Frank thing. It just, as soon as I said it, it felt like it's been around longer than that. That's in our proxy statement. Now circling around to the 10Q, the little brother of the 10K. I don't know why it's a Q. Q quarterly. That's it, I guess. K, I don't know. Okay, so the 10Q within either 40 days for accelerated filers and large accelerated filers, or 45 days for other companies after the end of the first through third quarters. The quarterly report on 10Q has to be filed. It updates investors on quarterly results throughout the year. Major part of that filing are unaudited financial statements for the quarter or the 6 months, 9 months ended as of the date of the filing. Those are condensed financial statements. They do include shorter notes than you see in the annual audited financial statements. And certainly these are not audited, although for a public company, they do have to be reviewed by the independent registered accounting firm. Another key component of the 10Q is an MD&A section, management's discussion and analysis. That's where management explains the key developments in the quarter. And then there are some other requirements about repurchases of stock or trading plans adopted by insiders during the quarter. But the idea is really that the 10Q is a shortened version of the 10K, and it builds off of the 10K and is supposed to focus on significant developments since the 10K. And again, there's going to be 3 10Qs during the year.
Thank you. And Rakesh, what about the 8K? What is the 8K and when is it used and when is it due?
The general concept is that public companies are supposed to be disclosing quarterly financials and annual financial statements. You're not entitled, generally speaking, to an update on each and everything that happens to the company during the quarter. In fact, the only things that you're required to be updated, to be provided an update on by the company is if certain items fall within the Form 8K. There are a lot of items within Form 8K, but considering the scope of any item or any happening that may happen at a company, there's a lot of ordinary course items that don't get included in a mandatory Form 8K filing. So some of the examples of things that are required to be filed on an 8K include the entry into a material definitive agreement, the termination of a material definitive agreement, certain executive compensation arrangements, M&A transactions, that kind of thing, bankruptcy, cybersecurity, financial developments like earnings releases, impairments of assets, material impairments of assets, triggering events under credit facilities that are events of default, delisting from national securities exchanges, and a whole host of other things. And so each one of these things can involve quite a complicated set of considerations in terms of determining whether the trigger has been met and needs to be an 8K needs to be filed. If an 8K does need to be filed, if it's a mandatory disclosure under a Form 8K, it's required to be filed for the most part within 4 days from the triggering event. Certain things like earnings releases have to be filed right away. But in addition to the mandatory 8K requirements, triggering items, companies can choose to voluntarily disclose items, again, usually viewed with the lens of holistic materiality to the company and to investors. And so you are permitted to include items on an 8K voluntarily, but companies usually grapple with those decisions because you don't want to set a precedent of, again, disclosing each and every happening in a company. Daniel?
Thank you. And Stephen, SOX implemented an internal controls requirement under Section 404. What are internal controls, and can you walk us through Section 404?
Yes, so internal controls refer to in the processes, procedures that a company has in place in order to be able to collect the information that's needed to prepare financial statements on a timely basis, to ensure that that information is accurate, and to take reasonable steps to prevent fraud from occurring and being reflected in the financial statements. And so Section 404 of SOX received a lot of attention because it imposed what some thought would be burdensome and costly requirements on publicly traded companies to document internal controls and then to assess them quarterly in the Ks and Qs, where management has to certify whether or not, based on the assessment that management did of the operation of those internal controls, whether they were effective to prevent at a reasonable level to ensure the accuracy and completeness of financial statements. Then another component of Section 404 is that for companies that are not exempt, so public companies, larger public companies specifically, in addition to that internal management assessment of the effectiveness of internal control, to annually have their independent registered public accounting firm to conduct an audit of management's assessment of internal control. This imposes additional costs on top of the already significant auditing fees that these firms charge. And so in recognition of that, the SEC does have some exemptions for smaller companies, specifically those companies that qualify as a smaller reporting company in terms of their filer status, and then also emerging growth companies, which is a category that the SEC developed to facilitate more companies becoming a publicly traded company.
Thank you. Okay, SOX compliance is a big issue for the SEC. How has SOX compliance affected the boards upon which you sit? And can you tell me if there's been any effect on the private company boards to which SOX generally does not apply?
Yes. So SOX compliance has been really, really important in a lot of the discussions, particularly in the audit committee. So you have a lot of extra controls and procedures that the auditors will need to see. You will have internal policies that you need to follow related to Sarbanes-Oxley controls. It's kind of interesting to me that we actually still call it SOX. It's now just part of the law and part of what everyone has to do, right? I mean, it's a very old law, but they're, at the same time, so is the 33 Act and the 34 Act. So maybe this one is still in its early stages, but it is really important. All these items are sort of infused throughout certifications, throughout procedures internally, and dealing with external parties. And now they have started to really be an important component of all the technological systems that happen, including Sarbanes-Oxley, cybersecurity considerations. Just as a reference point, though, Sarbanes-Oxley applies to all companies, whether or not you're private or public, for criminal liability for document destruction that impedes a federal investigation. And SOX for securities fraud is extended to 5 years for all companies, and debts incurred for violations of securities fraud laws are non-dischargeable in bankruptcy. There are increased liabilities for white-collar crimes and whistleblower liability provisions for retaliation, which apply to private companies as well. Now, a lot of these things are less relevant on a day-to-day basis for private companies because You know, I don't think you necessarily need a robust policy to say that you shall not destroy documents during a federal investigation, but it is something to keep in mind.
Thank you. And we're down to the last couple of questions. We're going to turn to Amy. Amy, we've discussed SEC and SOX compliance in detail. From your perspective, advising companies in both domestic and international contexts, what are some of the biggest challenges in cross-border securities ownership and transactions for in-house counsel?
Well, one of the biggest challenges I see for in-house counsel, U.S. in-house counsel, dealing with the cross-border securities ownership is that the rules don't line up across jurisdictions. And I mentioned that earlier. In the U.S., you have a 5% beneficial ownership disclosure requirement under Section 13D, but in the EU, the threshold can be 3%. In other markets, it's 10%. So if your company has global investors, you might be compliant in Delaware and with the SEC if you're still in Delaware, but already out of compliance in Brussels. So you need to really drill down and understand who your investors are and where their securities are held. That's especially true with maybe not the large multinational corporations, but smaller corporations who are still attracting investment from outside the country, even Canada. Believe it or not, that's a cross-border securities issue right there. So, so think about that and make sure that your boards understand again, like who the money's coming from and how much of an ownership stake it represents. The second biggest challenge that I see is the sanctions and anti-money laundering, because it's not always about who's the majority shareholder or who owns that 5 or 10% foreign stake. It could be more about that 5% foreign stake coming from the wrong party. So now you have not just this sanctions exposure, but you also have reputational risk. And that's where we're seeing governments that might be using securities ownership as a tool of their own national security policy. You don't want to get caught in the crosshairs of CFI US in the US or other equivalent regimes in Europe and Asia. So ultimately, in-house counsel ends up wearing two hats. Make sure the filings and disclosures are technically correct, as we've discussed throughout this entire hour, but also educating the board that a relatively small foreign investment might have strategic consequences.
Excellent. And one of the things that, you know, I spend a lot of time in is privacy and cyber. And I think with, especially with EU citizens who invest, you got all kinds of privacy issues and challenges. So again, where you have companies from the EU that are public on New York Stock Exchange or exchanges here. And again, adds a whole other layer, like you said, this foreign beneficial ownership and who owns the stock could be fraught with a lot of peril. So our final question for you, Amy, is for in-house teams and boards who are already feeling stretched thin and which board or in-house counsel isn't, how can they practically manage compliance across jurisdictions, especially when securities law intersects with data privacy, M&A, and strategic decision-making?
Well, my first tip is hire an associate or an intern, get some help. Yes, you're going to be stretched thin, especially with all of this compliance. And we've just touched the tip of the iceberg, as Rakesh said, you know, on the K's and the Q's and when something is or is not disclosable or reportable under the securities laws. So my suggestion would be try not to do everything everywhere, you know, across the entire world or galaxy. Use a framework. Map out what obligations apply, and that's your SEC filings, but also your foreign beneficial ownership rules or sanctions checks or data privacy rules, like you mentioned, Dan, if you're collecting investor information. So map it all out, then prioritize. Not everything carries the same level of risk. Your boards need to know when they're taking risks, and if they're going to take a risk, they need to take a smart risk. They need to understand the level of risk that they're taking. So focus on areas where a misstep is material, like securities ownership disclosures, or like I said, sanctions and the AML laws, or inconsistent filings even. You don't want regulatory scrutiny. And then use local counsel. Don't outsource your responsibility. You're still responsible, but use local counsel. Hire that associate internal as well. And then keep a master compliance calendar and a dashboard internally. It's something that I do and I share with my boards so that they can see and have that peace of mind that everything that needs to be handled is handled. Lastly, educate your boards. Boards that hear about cybersecurity or ESG at the same time as they're hearing about foreign ownership rules, they're less likely to be blindsided by what they don't know. So integrate these updates into board agendas, make sure that you talk about it, and ultimately you just want to simplify, centralize, and educate.
Well, thank you. And as I used to teach accounting for lawyers, and as has been mentioned earlier, each of these topics and each of the 15 or 16 questions we covered with our amazing panel of Amy, Stephen, and Rakesh. If you want more details, feel free to reach out to any of them. Audience, this concludes our webinar. Thank you for joining another entertaining yet educational production of Financial Poise. And I hope you learned as much as I did. I have the easiest job in the world of just moderating and listening to experts speak for an hour about important topics for you. So until next time, this is Financial Poise. Thank you.